Criminal Justice, and I'm going to suspend it and close it until recess it until Representative Roy, Chairman Roy, gets here. He should be here in about 5 or 10 minutes. He's not usually late, so thank you.
already opened and recessed. We're going to reopen at this point our committee work session on our retained bills. If you wouldn't mind joining me in rising for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. And with that, we will begin our discussions with HB 102 relative to the oversight of federal law enforcement actions. Would anyone like to speak with thoughts on this? Remember, this is a committee work session, so feel free to weigh in on any of these. We will be executing them this afternoon. So if you have an opinion you'd like to share with the committee one way or the other, now is the time to do that. Representative Scher.
Yeah, as we discussed when this bill first came in front of us, I think the idea of oversight in the way the bill talks about is probably unconstitutional. And what's going to happen is the federal government will just ignore it. So I think
I'd have to interrupt and say, no way.
so I'll leave it at that.
Anyone else? Anyone from in the gallery that would like to speak on any of these? We're willing to hear your input today. Seeing no one. Anyone else? Okay. This will be put aside for this afternoon's exec. Next up, we have HB 194 relative to the crime of interference with custody. Anyone want to speak about that?
Yes, Chairman Roy, I have proposed an amendment that we could add to the executive session this afternoon. It's a 3 strikes amendment to 194. This would make it so that way the first or second violation is punishable by a fine of $500 per offense. Again, this is relating to interference with the custody of child. A third or subsequent violation makes it a Class B felony. It's a 3 strikes. The reason why it's 3 strikes is we do not want to have the consideration is for the children involved in these situations. And we do not want to have them to deal with the trauma of having a parent taken away by law enforcement at the first sign of a dispute between the parties. This allows for the parents in the situations to kind of improve in their relationships with each other and perhaps learn from their mistakes.
If I recall, the original bill, it became a felony much quicker, did it not?
Yes, sir.
Yeah. Okay. Anyone else? Representative Scher.
Sorry, this is probably going to be a regular thing today, but my concern with this bill, as I articulated last spring, is that I think everybody in this room knows how, to use the formal legal term, how messy child custody issues are, and how hard it is to sort out what's actually going on, and how strong the emotions are on both sides, and kids are often caught in the middle. I'm very, very concerned about criminalizing this. I think, as we talked about in the spring, in spite of what apparently some police departments believe, they can be called to a scene to sort out custodial circumstances. I think the issue here is more about education for police departments. County attorneys need to train the police departments that they have supervision over, that they can go to a scene where there's a custody dispute, depending on what the child custody orders are. So I just don't think it's a positive thing to start to criminalize some of this behavior. It'll make things worse. It won't make things better.
Thank you. But could you address the amendment? I mean, the amendment actually gives them 2 chances where it's not criminalized. It's a civil violation with a fine. It only becomes criminal by the 3rd time they've actually violated the court's orders with regard to custody.
I don't think, having been divorced before and having had a 6-year-old child during the divorce, while I was lucky in that my ex-wife, almost ex-wife at the time, and I were able to talk to each other, the degree of emotion involved is in child custody circumstances. In all the conversations I've had with friends and others who I think everybody on this committee knows of otherwise smart, intelligent, thoughtful people losing their minds when it comes to divorce and child custody. It just happens. And I wouldn't, I don't think it should be a violation. I think the person should go back into court and it should be dealt with in the civil context of a person goes back into court in front of the judge who approved the child custody situation, and the judge makes a determination whether that individual is in contempt of court, rather than putting a person on this track. I think that process already exists, and I much prefer that we use that process and the contempt of court process which can be a misdemeanor, rather than, put somebody on the track to an otherwise intelligent, thoughtful person on the track to becoming a felon because they lose their mind about child custody.
Thank you. Any further discussion? Yes, Representative.
Representative Swanson from Nashua. Thank you, Mr. Chair. I meet with or encounter people on a routine basis who go through the difficulty of family relationship and understand the emotions involved that are pointed out. And I am not sure that within this effort there's, and perhaps this has been discussed before as far as the examples that provide evidence that adding or further criminalizing, even with the amendment, adding the felony seems unnecessarily punitive and only causes or inflicts further harm or provides a potential for that further harm to the families and loved ones. And this is basically, the outcome is ultimately negative, just having this in statute versus leaving it up to the courts to decide.
Thank you. Yes, Representative Prue.
So I hear your arguments, and granted, people do get carried away, but you're giving them 2 chances to get their thoughts together and figure it out. By the 3rd time, if they haven't figured it out, there needs to be something that really reins them in. So otherwise, they keep repeating, right? Some people, $500 is really nothing to them, and they'll just keep repeating. So you have to put something there that says, hey, you got 1 shot, you got 2 shots, 3rd time, you really need to stop. And because the children will just keep seeing them arguing and on and on and on. So I think there needs to be something that puts them back in front of a judge that has some power to make them stop. Thank you.
Thank you. Representative Scher.
There we go. I understand what you're saying, and I think that power already exists. They can go back in front of the judge who ordered the child custody, and the judge can change the custody arrangement, can find them in contempt of court. The judge has some mechanisms. I'm uncomfortable with it leading to misbehavior of this kind, leading to a felony conviction.
Would you not agree that there are parents, single parents, without the ability to pay for counsel to keep going back and forth? I mean, I don't know of any attorneys who will go back to court for free and keep bringing these type of issues when you have a recalcitrant parent who keeps disobeying me. So is there not a cost and impact on people?
Well, I think there's plenty of divorces and child custody situations that people are pro se. They represent themselves. It's a common thing. I don't know whether it's more likely that than having a lawyer. So I think I think if the court orders them back in, one of the penalties they would suffer effectively is if they want a lawyer, they'd have to pay for a lawyer. So, I think that process exists, enough process exists now that will make them get the message. Be it a contempt of court with a penalty associated with that, I've had my say. I'll shut up now.
So I'm going to put you down as a no, probably. Okay, anyone else? Yes, Representative Muse.
So just a reminder that a Class B felony requires a minimum prison sentence, and typically those sentences are completed up at our state prison. My understanding is about 85% of the people who find themselves in this situation are women, and many times these are women who are victims of domestic violence. So I think anytime we have a bill in front of this committee that raises a penalty or implements a penalty where there hasn't been a penalty before, one of the things we really need to seriously consider are what are the implications of sending a person up like that up to prison, sending a mother up to prison away from her children in a child custody dispute. And I think, as Representative Scher has said multiple times, we do have a court system that's set up to address and handle that. These cases have been handled civilly, and one of the things that I haven't heard in any of the testimony, either today or in previous sessions, is how many people are we talking about? How big a problem is this actually? Nothing on that. And so my preference is not to legislate on hypotheticals, especially hypotheticals that involve penalties that will send people to prison for a year or more. So that's the way I feel about it.
Thank you. And just to be clear, regarding your reminder, actually, there is no mandatory jail sentence with a Class B felon. It's up to the judge. They don't have to sentence them to prison. If they sentence them to prison, there is a range they have to be sentenced to, but they don't have to be sentenced to prison, and the sentence can be suspended, or there's all kinds of creative ways that do not end up in prison. And I would hazard a guess that the vast majority of cases that are brought into court as felonies do not go to prison, much to the chagrin of some of us. Seeing no further discussion, we'll move on to the next one. We're ready for that this afternoon. And now we're going to take up discussions on HB 206 relative to the government agent entered into secure premises. Would anyone like to open the discussion on that? I believe this was regarding posting land. And we heard some testimony that the way it was written, there were some problems related to civil responsibilities of the municipalities that require them to go onto private property, and this would prohibit them from carrying out their jobs, if I recall correctly. Any Representative Scher?
I think we did hear that. There's, somebody checking a meter, for example, or doing executing an administrative search. My broader concern is, are we really currently under the U.S. Constitution, police can enter even land that is posted, can enter what's so-called the back 40. That's not part of the curtilage without having a warrant. It doesn't count as a search under the U.S. Constitution. I don't know effectively if this is really amending and saying, well, yeah, that's maybe what the U.S. Constitution says, but we're going to treat it differently here in New Hampshire. And I'm uncertain. I'd be curious what, just to put him on the spot, I'd be curious what Representative Lynn has to say about this, because it causes me some concern.
Thank you. If I recall, there's a doctrine in play here that the Supreme Court enacted that allowed the police to enter people's property that was not within the curtilage
Yes.
at their will.
It's called the open fields.
The
doctrine.
open fields, that's what it was, correct. So this would be narrowing that, and it's my understanding that a state can narrow the government's abilities. In other words, expand on the citizens' rights versus doing the opposite with regard to the two constitutions. Is that correct, Judge Lynn?
Yeah, no, I think that is correct. I mean, I agree with what Representative Scher said, but I do think that the state would have the power to provide more protection if it wanted to. I mean, given the limitations of, it needs to be posted or whatever, I personally think that would be a good idea to provide more
More protection.
protection.
We heard testimony, if I recall, from law enforcement that it is their practice, if they do see a posted sign, to not enter the property or get a warrant. However, we do know that that is not universal, and they can, in fact, go onto anyone's property they wish without a warrant, as long as it's not within the curtilage, if I'm correct. Further discussion? Yes,
Yeah,
Representative.
the confounding piece here is, and my guess is, at least for some, this is the point of this legislation is what federal officers are they bound by this legislation, or are they bound by the open fields doctrine that's federal law? That's it. It's my understanding is it's not a simple answer to that. When federal officers are entering, I think this dodges that, doesn't make that clear one way or another. I would guess, and again, I would estimate that federal officers would say, we don't have to follow this. We, under the open fields doctrine that the U.S. Constitution has laid down, we can enter the property without following these strictures.
I think that would end up as an interesting court case, deciding whether or not, if they were operating on based on a federal law, that they, although the point of it is, I believe, if there was a federal investigation that they wanted to go into someone's property, they would have probable cause by that point, I would think, to get a warrant anyway. I don't think they have the resources to be wandering about the state of New Hampshire just looking for crimes. I would imagine that most New Hampshire citizens would be involved with New Hampshire law enforcement under this situation. So even if it didn't extend to federal, if the state were to try and circumnavigate that law by partnering with their federal friends, that would cause a problem for them down the road.
And
Anyway, I think.
just
I see, Representative.
oh, sorry.
No, let's go ahead and finish what you thought.
In reading this even more closely, this is limited to local or state officials, the definition of government agent. So this doesn't apply to federal law.
Well, it was an interesting sidebar anyway.
Yeah, we can continue with interesting conversations.
Representative.
So as I'm reading this, I have concerns. As a firefighter, we have the ability to go onto property when we suspect there's a fire or somebody's burning illegally or we're looking for fire. And I don't see us in kind of vague in the exceptions. Maybe we can fit in there, maybe we can't. That somebody could say, no, you can't come on my property. I don't care if it's burning or not, and you can catch it when it comes outside my building property. So I'm just a little concerned in my
It would limit you to making a fire break, I would.
Yeah.
Thank you.
Maybe that should be added to paragraph 8. Yeah,
Yeah,
it says the provisions of the section shall not apply to conservation officers, other officers of Fish and Game Commission.
Yeah, it would, if we were to entertain it, it certainly would need an amendment. Anyone else? Seeing none, we'll move on to the next bill. That would be HB 257, establishing the crime of criminal neglect of a child. I believe Representative Love would like to address the committee. No, Oh, okay, excuse me. I'm sorry.
I do have an amendment that I proposed last spring. We never heard it because we retained this before we got to the amendment, and I can pass that out now.
Yeah, please pass it out. We're not going to introduce or take up any amendments, but we can discuss
But
it. Let's hear about it now.
If you want me, I can, as it's being passed out, I can
Yeah,
describe it. We had a difficult discussion. I mean, I understand the point of this. I understand the point that the Sullivan County Attorney and the Stratford County Attorney were both trying to make, that they see cases come before, that don't come before them, that have resulted in significant injury or death to a child, that they wanted more power to get involved in ahead of time. I think that was the basic idea behind this legislation. And I, as a principal, I don't have any problem with that. My concern is this. DCYF is the primary government agency that handles child abuse circumstances. And they have a very robust, perhaps understaffed, but very robust system for handling child abuse. My concern is that while we want to have the criminal system be able to intervene in more of the circumstances than they currently intervene in, I think dropping the mental state to negligence and creating a whole new statute goes too far. I think we need to take this step by step. My amendment basically is a replace all amendment that instead looks at the existing endangering the welfare of a child or incompetent. The county attorney's problem with the endangering the welfare statute is that it had both a knowingly and a purposely mental state, which made it hard for them to intervene in that circumstance. And I proposed last spring, and I bring this back again, making a change in the interest of allowing the county attorneys and prosecutors to get more involved in more serious cases, changing the mental state to recklessly, which gives them authority to get involved in the more serious cases earlier. I think that's a good measure to start with to see if that works. Part of what underlays my view on this is I don't think the criminal justice system handles these cases very well. You know, they're not set up to do the array of things that DCYF has the power to do. I think putting the parents in the criminal justice system means that prosecutors are going to be making judgments about what the sentence should be, and that people and that they have limited array of mechanisms to help parents work through this. And what they're doing is giving a parent a criminal conviction rather than working it through this civil system. I mean, what we're trying to do is we're trying to find that sweet spot where we get to enough of the cases that are going to be trouble using the criminal system because they're serious enough. We want to get there, but we don't want to put too many parents in the criminal justice system. We'd rather have them work through the civil justice system, the DCYF system. So I think my proposed amendment hits the sweet spot better than 257, which has a negligent mental state, which is a much easier mental state to meet. I agree that the knowing and purposely is too high a mental state for child endangerment, but I think a reckless mental state finds the right balance.
Thank you. The committee received written testimony from Detective Alex Marvin. Are you here today? Would you like to address the committee? Okay. If you could just introduce yourself before you begin speaking.
So my name is Alex Marvin.
Could you turn on the mic?
My name is Alex Marvin. I've been a police officer for a little over 11 years. I'm a detective sergeant in Newport PD, and for my responsibilities, I handle all crimes of intimate partner violence and sexual assault, child abuse, things of that nature. I've brought you my testimony here in the past, so I'm not going to go through and read the whole testimony again for you. But just to echo what we said before, we are trying to address a gap in the law. I actually agree with much of what Representative Scher just said. DCYF does have a system in place. We work very closely with DCYF doing multidisciplinary investigations. And certainly criminal involvement is not necessary in every single case. There are absolutely cases where it's the most appropriate thing to go through these civil resolutions under 169 and address things that can be addressed in the civil matter. What we're looking at here are the cases, not those cases, but there are many cases where you're in a lead a horse to water type situation where resources are being offered, DCYF is doing the things that they can do, and it's still not effective. And in the meantime, as we're going through these long drawn out court processes, these children are oftentimes still subject to neglect and at times abuse. I have the utmost confidence in DCYF. I work with them very well and I respect them a lot. But many of the workers on the ground will be the first ones to say they cannot do this all on their own. They certainly try and they do a great job, but there are cases that go far beyond what they can do. And in those cases, we're left in a bad spot because we don't have the tools necessary. In an ideal world, I think negligence is appropriate. However, based off what Representative Scher just brought forward, I don't disagree with what he said. And I think recklessly would help accomplish what we are looking at. Not as effectively, but it certainly would help.
Have you seen the amendment that Representative Scher's proposed?
I have not. I'm just going based off what he just said, but I've not read it full.
I think there might be a copy.
Please give him a copy so that he can look at it. Because it's a totally different statute than what yourself and the county attorneys had proposed.
Wasn't this the bill that we made it to the floor and then we kicked it back to us?
Yes. Just while he's reading, I think the value, what you get with recklessly is if they've been engaged in the DCYF system for a while and things haven't been going well, it's going to be pretty easy to establish recklessly because the reckless mental state is you're aware of a substantial and unjustifiable risk of harm, this kind of harm occurring, and you nonetheless continue to act. If they've been involved in the DCYF process and not cooperated, not been successful, but been made aware by the nature of the process that there are these risks there, I think proving recklessly is going to be pretty straightforward.
Detective, do you have any thoughts after having a look at the amendment?
In looking at the amendment, I think that it accomplishes a very similar goal. Certainly, the language is different. We drafted an amendment to the original House Bill 257, where we took out a lot of the things that were in there that were explicitly stated and left a little bit more open-ended. In the amendment that we made, it ends up being extremely similar to this. The only thing that is different really is the mindset of recklessly versus negligently. Again, I do think negligently is more appropriate. However, my interest here is just serving the kids, and if a compromise can be met with that mental state of recklessly, that will still give us not the complete toolbox we're looking for, but it'll certainly give us more tools.
Well, Representative Scher can give us a definition, I'm sure, but as someone who would be enforcing it, what is your understanding of the difference between recklessly and negligently?
So recklessly is a slightly higher mental state, and what he says is correct in that if they are engaged with the DCYF system, it'll give us the ability. It fits better into recklessly. Negligently, I mean, to make it as simple as possible is you didn't do something that you should have done. And then recklessly is more of you did something that you probably shouldn't have done, and then it's slightly less than knowingly. So without having a specific case in front of me, it's a little harder to come up with a circumstance comparing them. However, like he said, if they have not been in the DCYF system prior and we have not tried other interventions, recklessly would be appropriate. Negligently would give us the ability to intervene a little bit earlier. because there are cases where I don't know best way to describe it. You have families who I guess are ghosts to say. I
Actually,
just had one where they're
could
not.
could you give us a hypothetical? I don't need a specific case
Hmm.
where this statute would apply. In other words, if there's child abuse occurring,
Hmm.
obviously you can intervene immediately with assault or any of the
Sure.
other charges that are at your disposal. So how would this apply to
So,
it?
so I guess the easiest one to bring forward is one that we see quite often, is when you have parents who are not attentive to their children, and that can be for a whole multitude of things. That can be drug abuse, whatever that may be, and you have the children wandering out of the house.
Yep.
And we're finding a 3-4-year-old child wandering down the street in the middle of the night, and you're bringing the kid back. And with the current endangering the welfare of a child statute, where we're talking about purposeful, that is not purposeful conduct. They were negligent, maybe even reckless, but it doesn't really fit into the definition. You have to establish all sorts of other factors to meet that current threshold. And we've actually had cases like that in Newport, one of which where a 3-year-old child died in the night, wandered out of the house. It was 8 degrees below zero, and the child ended up dying. And then we've had other cases where there was one particular case where I believe we ended up having to bring this child back 4 times before we were able to finally get to that purposeful standard. So working with DCYF in those cases is always appropriate because they can work with the family and give them resources, but those resources take time. And when we're talking about a child wandering out of the house in the middle of the night or the middle of the day, we don't have that time if that's a habit that child has. We're waiting on that child to get hit by a car or something terrible to happen because we can't act with the statutes we have now. So just off the top of my head, that's the easiest circumstance that I can think to bring forward to you.
Just to,
That's incredibly helpful. Representative Scheer.
yeah, just to continue that discussion and with that example, I think the first time it happens, the child wanders out of the house, you and or DCYF come to the parents and talk to the parents. If it happens again, you can charge recklessly because they are to charge recklessly. They need to be aware that there's a substantial and unjustifiable risk of harm happening.
I would make the argument that having numerous children myself, I would make the argument that anyone letting their 2-year-old or 3-year-old wander about unsupervised is reckless. And you could on
Yeah.
the first.
I mean, I think that's a legitimate argument to be made. But it's clearly, if it happens once and they're warned, then
Yeah.
it's clearly going to be recklessly. And so I'll leave it at that.
Yeah. Anyone else? Thank you for oh, yes, I'm sorry. Go ahead.
Thank you, Mr. Chair. This is not really, well, I guess this is related insofar as given the number of times that my wife has asked me to get something from the garage and I negligently forgot to bring it back. I would hope that, and I don't believe it was ever reckless or willful. I would think that adding reckless here is probably the appropriate thing to do.
Thank you. Did you want to respond to that? You don't have to.
No, I don't think I have a
Okay.
good response. I think what my previous testimony speaks for itself.
I don't know about the garage thing. Mine's a mess, so I'm reckless for just probably having it.
You've certainly been negligent.
I have definitely. Representative Murphy, did you want to add
Thank you,
something?
Mr. Chair. Yes, I'm happy to see that we have something, an amendment that addresses the issue, because I was one of the people that was really concerned about this bill, and having worked formerly for DCYF, I get it, that there are those frequent flyers that just we don't get. And at that point, it's not about the parents, it's about the child. And I think this is one of those opportunities that we have to do something. And I'm happy to hear that you think that it would address at least a step forward to put some teeth into something that would allow law enforcement to do their job and protect kids. So just want to make that point. Thank you.
Thank you. Yes, Representative Muse.
One of the main takeaways I've had from the testimony is that we do need more tools in the toolbox, when it comes to cases like this. Another takeaway from the testimony that we had in the spring is that there are lots of issues with the bill as it's currently written. So Representative Scher's amendment, to me, seems to be a pretty good place to go. It's a good, solid first step that may not solve every issue. It may not give everyone every tool that they want, but it certainly does seem to provide more latitude for police and how they respond to situations like this. And it does create more accountability for parents who recklessly behave this way. So I would support what Representative Scher is trying to do.
Thank you. Seeing no further discussion on that, we're going to move on. Thank you for speaking with us this morning. HB 330, relative to establishing penalties for violation of confidentiality of motor vehicle records. If I recall, we had issues that were arising where stores or other places, for example, that sold cigarettes were actually scanning people's driver's license, and the concerns were, where was that information going? Were they keeping it? Were they selling it? What information were they getting off that scan of the driver's license? I think that's where we're at. We had some testimony, if I'm correct, if I recall, from someone representing stores that were doing this, and they said that as the proposed statute as written would cause problems for them. Would anyone like to weigh in or add or help me if I'm not recalling that correctly? Representative Lissell.
Correct me if I'm wrong, but there are stores who routinely make a copy of a person's driver's license for purposes of identification and for routine matters that have no intent upon giving that to anybody else. It's retained locally. And I would hope that anything that we would do here would not make that routine use of identification more cumbersome on the part of businesses.
Thank you. Off the top of my head, as far as copies of the license, the only one I can think of would be like car dealerships routinely try to grab your license when you go in there and you want to do a test drive of a car, which it's probably helpful for them to know who just drove off with their car. The concern was the ones that were actually scanning it, because I was concerned of, and this isn't my bill, but I was concerned what information is in that barcode, and once it goes into a computer system for that store, where else does it go? I understand that information like that is actually valuable and purchased. There are companies that purchase information just to have that information. So I don't recall. Does anyone else recall what we heard?
I remember hearing that if this bill were to pass as it was, I remember hearing concerns about people being able to open up bank accounts. I think I also remember hearing concerns about hiring practices.
What were those? Oh, you mean with regard to copying someone's
Right,
license when you
yeah.
hire? Well, that's required, I think, by federal law. When you do is it the I-9, I think it's called, when you hire somebody. So I feel like there's a lot of questions that are still surrounding that. Is anyone here from the gallery? Yes, sir, come forward. My initial instinct is to suggest we talk about interim study later, because it sounds like there's a lot of information still that is.
Thank you, Mr. Chairman, members of the committee. For the record, my name is Tom Praisall from Demers, Praisall and Thomas. I actually have numerous clients who have concerns with this bill, including the mortgage bankers and brokers. I know somebody is here from the Bankers Association. In addition, I represent the New Hampshire Retail Association. So in reference to your questions about, purchasing cigarettes and alcohol, the legislature actually passed a bill this year. I think it was House Bill 77, that allowed for the scanning but prohibited the retention of the information. And that was worked on in conjunction with the New Hampshire Liquor Commission to ensure that, there's age verification processes in place, but they cannot retain that information. But I think the way the bill is written, there's a number of issues, you know, one off the top of my head, that's kind of a real world experience that many of you may have been through is if you go to Home Depot and you want to say, use one of their trucks to bring home a new grill that you purchased. This bill would make it $100,000 fine if they were to get a copy of your driver's license showing that you are able to drive that vehicle of theirs off the lot and home and bring it back.
All the rental, because you can rent numerous tools there as well.
Yeah, absolutely.
Yeah.
So I think there's just a number of those issues. I think from the mortgage perspective, if you want to refinance, I think there's a Patriot Act form that requires your ID. I think there's federal law, and that's also part of the Bank Secrecy Act. There's also federal laws around meth checks for purchasing mass amounts of Sudafed to insure against that. So I think there's a number of
Actually, I
concerns in
hate
here.
that law, but yes.
Yeah, but it
I
exists.
just want to grab the cold medicine,
Yeah.
I really do.
But I also want to point out that the legislature a couple years ago also did pass a comprehensive privacy bill that allows for an individual to reach out to any business and have their information removed if they so wish. So with that said, I don't hate your idea of interim study. I mean, an ITL would be great, but I'll leave that to you.
Interim study and ITL are just different looking birds, but they both fly the same. Yes, Representative Scher.
I feel an obligation to continue to say something about everything. I think interim study is a good idea. I think this bill may work if language is put into it that limits the use of the copy of the driver's license to the specific purpose they requested the driver's license for. So that, and I think you might be able to write something that accomplishes what we want.
Yeah, if I were to entertain doing anything even related to this, because there's so many other federal statutes and even our own statutes that intersect with this that I don't like it. But if anything, I just don't like people selling other people's information. So that's something I would entertain. If a business were to take it for a legitimate purpose, but then compile and sell that to a information broker, that would be problematic in my mind. But are you aware of that being a problem?
I haven't heard that.
Yeah, so, yet. Well, but we're not gonna write future laws yet, so, okay, thank you. Thank you for addressing this.
Yes, you bet.
Anyone else want to speak on this bill? Okay, seeing no one else, we'll move right along to HB 609, relative to General Court's authority over the sale, purchasing, ownership, use, possession, transportation, licensing, permitting, taxation, and other matters pertaining to firearms, stun guns, and tasers. I'm not sure if I'm gonna remember this one correct, this was about,
Sir, this was the campus carry bill.
this was the
The
campus.
legislative intent behind this was campus carry.
Okay, thank you. Would you like to address the?
Yeah, I can give a brief summary. My name is Sam Farrington. I represent Rochester Ward 4. So this bill deals with Section 26 of RSA 159, and that's the preemption statute, which basically says that all authority regulating firearms, it belongs to the state of New Hampshire. Well, right now, you have certain state agencies like the Department of Transportation that says if you're a state employee, you can't carry on the job, which is an infringement on their Second Amendment right. And so the idea with this bill is not to change the statute in any way, but rather to clarify and to strengthen the statute by giving all authority to the general court. So changing state to general court, adding some other protections, excluding rules as well, because these agencies have adopted rules. And yeah, that's the intent with the bill. I remember before there was some question on courts and whether this would conflict with that. But Section 19 of RSA 159 separately deals with courts, so that would not be in conflict with this bill.
Okay. Were you the sponsor on this? Okay.
Yes, sir.
Okay, thank you very much. Anyone have any?
I'm
Yeah.
sure Representative Scher.
No.
I apologize to both of you, but I have no comments on this bill.
I'm a little concerned about the rest of the day. Representative Muse.
So can A concern that I have is that they're currently on the seacoast. One of the events I think that a lot of our residents look forward to year after year is the air show at Pease. And so currently, you know, if you take a look at the Thunder Over Pease page, one of the things that that they're done, or that the air show lists on its page, is there's a list of things that are not permitted in the air show. And among those are weapons of any type, to include but not limited to any firearm or weapon capable of launching a projectile, including guns and slingshots, all knives, switch and spring bladed, stiletto, trench, machetes, straight razors, throwing stars, nunchucks, sand and blackjack club weapons, batons, and metal knuckles. I think part of the reason why there's a restriction like this is we're talking about an active airport, and the agencies in question, as I understand it, are the Pease Development Authority, as well as the New Hampshire National Guard. And the way that I read your bill is that they would no longer have the ability to actually prohibit any of these things in future shows. Is that correct? My understanding correct?
Do you know who owns Pease Airport?
What's that?
Who owns the property?
Who actually owns the
Yes.
property?
Well, isn't it it's an airport
Facility.
correct?
So it's the federal government. So
Yeah.
this, I mean, sentence 3 right here says to the extent consistent with federal law. So this would not contradict federal law in any way. Take the Gun-Free School Act, for example. This would not contradict with federal law. So I don't see that as being.
Although it does raise an interesting question for me. What about, so this wouldn't apply to private agents. So example,
Business.
concert events. If
Yeah.
a concert says no firearms, that they can do that. This wouldn't interfere. As long as it wasn't a government agency is what this bill would do.
Correct.
And that would be only a state government agency. So federal property, if they just say there's no guns allowed on Pease Air Force Base, this bill doesn't matter.
The original law was passed because the state wanted to prevent towns or cities from having certain gun control.
Okay. I have another question, because the way I was reading this last night, this is also is this the one that deals with preemption as well, as far as like towns putting restrictions on pepper spray or
Yes. Yes.
electronic tasers or anything like that? Are you aware of any towns that have passed anything infringing on the rights of those type of self-defense?
Not to my knowledge, but right now, just clarifying and strengthening the
Yeah.
statute would be a good action.
Thank you. Representative Scheer, I knew it.
I mean, well, for the record, the chair provoked me.
I did.
While the airport is owned by the federal government, the entity making the rules that Representative Muse articulated is a government authority. It's the Pease Development Authority. So that's a quasi-local government authority. So I'm not sure it answers the question. That I'm not sure this bill doesn't apply to what the Pease Development Authority is ordering as to the air show. That, I think the problem is still there, even though the airport is owned by the federal government, the land's owned by the federal government.
So if I understand correctly, you're saying because it's a state entity or a local entity ordering no weapons at the event, even though the event is on federal property, it would invoke this statute.
Yeah.
If the Pease Air Force Base itself has a rule that says no weapons, it doesn't matter, correct?
Yeah, I don't know whether.
I don't either. Generally, I think military bases have a policy with regarding no weapons.
Yeah,
They can
but
order that because it's federal property.
Right. But it's still an interesting question.
it's just messy.
Anything else? Thank you for refreshing our memory. Yes, Representative Pruitt.
The only reason they're posting that is they're informing the public that that's the policy of the federal airport. Would be my guess.
Anything further on HB 330? Seeing none?
There are actually
Oh, Representative Muse.
there are actually things in the prohibition that, for instance, if you were a passenger, so for instance, animals and pets other than service animals are another thing that's actually prohibited. That's something that most airlines make provisions for people to bring in. So ice chests and coolers, UHF and VHF radio transmitters. So there's actually, quite a long list of things that they're going to screen you for at the entrance. When you try to enter, basically enter the base, to enjoy the air show. I think one of the other things to recognize is, are we getting into sort of the same sort of hair splitting situation we get into with schools? So if we're saying, well, this is federal property, well, then would only federal officers have the ability to enforce these rules on the property? So for example, if you go to the air show now, local police are the folks who actually do a lot of the enforcement of this. Would they be able to do that anymore if a law like this was passed?
Yeah, I don't know. There wouldn't be enforcement of the law then, I guess, right?
A lot of them exist.
I would also point out that there's no constitutional right to a cooler or any of those other things versus the Second Amendment, which we have to keep in mind is actually a fundamental core right of the citizens of this country. Seeing no further discussion, we're going to move on to the next bill. Thank you again, Representative. HB 609 that's the one we were just talking about. HB 767, this is the one Representative Love wanted to talk to us about, regarding expanding requirements for reports of law enforcement by the Department of Health and Human Services. If I recall, we heard testimony from the Department of Health and Human Services that they did not like this bill. They did not want to have to report at the point that this bill was going to require them to, if I recall correctly. Does anyone else have any recollection on this? Representative Love, feel free to let us know what you think.
Thank you, Mr. Chair. Thank you, members of the Criminal Justice Committee. My name is David Love. I represent Rockingham 13, which is Derry. And to start off with, I don't want to try to minimize, my respect for DCYF in any shape, way, or form. They're understaffed. Their caseloads are very high, and I don't think I'd want their job. But to start off with, the analysis is wrong. A complaint of a crime, abuse, or neglect. Neglect is not in this. If you read the bill, I was on the committee to study DCYF last term, and a few times we heard statements from the public that DCYF told them that there's no broken bones, there's no hospitalization, there isn't much we can do. That exact statement was said to me over 20 years ago. Okay, my ex-wife was turned in 7 times. I only turned her in twice. 5 other people turned her in, and that's what we got. And I think when a child has been assaulted or sexually assaulted, especially, they deserve the same investigative expertise as any one of us would. I gave John Sipper, the head of the state police training. But anyway, John Sipper, and I gave him a call and we talked about it, and he said DCYF does not send any of their investigators for investigative training. I don't know where they get it, but originally DCYF was supposed to be a social service agency. We've heard testimony about programs and things like that they can refer families to, and that's what their original intent was for. And somewhere along the line, they turned into the investigative arm of the family court. Once again, we've heard a lot of talk about the family court. They're a civil court. They don't have jurisdiction to invoke penalties or anything like that. So why is an assault on a child any less important than an assault on me? It doesn't make any sense at all to me. They have the same rights, and we have more responsibility to protect them. DCYF doesn't have the training, the expertise, or the jurisdiction to bring these people into criminal court because it is a crime. And, you know, we have a chance to change that. DCYF, it seems like every other day you see, you read about a lawsuit because of DCYF not like negligence. You know, we've got a chance to change that. You know, let's give these crimes to the people who investigate crimes, the people that are trained in investigating crimes, and then they can bring it to a court where they have the jurisdiction to either fine or imprison or whatever. You know, what we're doing is broken. You know, and you know, with how many Montgomery? You know, how many times? You know, how many times were they sent out there? You know, and you know, everything we all hear it all the time. They fell through the cracks. Let's close the cracks.
Thank you, Representative.
Thanks.
Anyone from the committee want to comment or discuss this? Representative, I can't see it.
Thank you, Mr. Chairman. I just want to say I strongly concur with the sentiments that Representative Love has expressed this morning, and criminal behavior should be in criminal court.
Thank you. Representative Murphy, thank you.
Thank you, Mr. Chairman. I think Representative Love made some good points. And when he was speaking, he talked about, you know, multiple reports and things not happening as he expected they should. Having worked in the office, I was the nurse. I didn't do assessments or family service. So I dealt with all of the children that had broken bones or burns and all those other things. But I think the piece that's missing is, and just a bunch of cases popped in my mind. One, when Child Protective Service workers will go to court, I can remember a Munchausen by proxy case in Manchester. And at that time, the judge said, it is such a rare occurrence, what's the likelihood that one of these cases is going to end up in my courtroom? Thus, not a finding. I remember another case where we had a child that was very abused, and it was not criminally prosecuted when it certainly should have been, because we were told by law enforcement it was a large drug investigation, and that was the focus, and they were going to get the perpetrator on that. So it's not always DCYF. I agree there are things that we can do differently at DCYF, but I think it's the you know, there are levels of when a person calls into the hotline, cases are addressed on a time frame based on the seriousness of the issue. And I certainly support the effort, but I just also recognize that it isn't necessarily always DCYF, that there are other things we can do.
Yeah, agreed. But wouldn't you agree that at least it's better if law enforcement decides, you know, we're not going to do whatever, or the court decide, at least if they know about it and if it's reported to them, to law enforcement, then it's on them instead of leaving it on DCYF, who is understaffed. And so to say you have to report these to law enforcement, at least it gives DCYF the ability to say, okay, now this is yours now, and instead of them ending up always, because to your point, if they don't report it, there's no one else to blame but DCYF.
This bill, as I read it, would require that every single report be made to law enforcement when it comes into, like, the hotline. And what was I don't remember the testimony of law enforcement as to how this would impact. I don't actually remember if they even had input, but I'd be really interested in that. Just thinking of the number. I mean, what do we have? It was 5,000 cases or something that were level 1 and level 2. You know, and I don't know every law enforcement agency in the state and how they, what their interaction and their policies are with DCYF. I don't know. There may be some arrangements that they have that, okay, call us for X, Y, and Z. But I would be interested to see how that would work, just in terms of, I don't know the impact on law enforcement, and I don't know if that's the information I think is important to get to law enforcement. I'm not sure that it doesn't already. So I don't know. I wish there was somebody here to weigh in on that.
I did talk to my chief of police, George Fioli in Derry, and he's as appalled as any one of us with the crimes against children And he said his department would be more than glad to take it on.
As written, it requires, because I don't have the bill in front of me, it requires every call to DCYF to be forwarded to the police? Representative Murphy?
That's what it looks like to me.
Representative Long?
Accusations of assault or sexual
Oh,
assault.
thank you.
That's all.
Okay. Oh, so,
Can I just
yeah,
say one thing?
Representative Mannion wanted to. Yeah.
Yeah, I'm brand new here and I wasn't here for the first hearing, but it looks like it's not really changing the referral, just the process. So it says, because the language that's being changed is it's being changed to immediately refer, and it gives some ways to do it, verbally report to an officer. And then it kind of strengthens what the offenses are: sexually exploited, intentionally physically injured. And then the first section is new. So it's not really saying that, it's not changing how many cases are being referred, just the method by which they're referred, and it's changing a little bit of the language as to what offenses are to be referred. So I don't read this as being every single case that comes in is referred to law enforcement.
Representative LaSalle?
Yes, it's my understanding that if a child goes to school and has a situation or has an indication that they're being abused, the school district is required for them to report that to law enforcement. Why would the school district be responsible for reporting it and DCYF not?
Representative Scher?
I don't know where that comes from, but that's expensive. And it may be DCYF needs more resources. As a police commissioner in Portsmouth, I talked with our chief generally about this, and his belief is, well, I mean, we're already understaffed. We're down 6 officers, and we just, we don't need this many cases coming in that we would have. And, once it's reported to them, then the police department assumes an obligation to investigate in some fashion. So it would be a burden on police departments. I don't think we need to be cognizant of that.
I know that's not, this is not what you're inferring, but I'm going to say it anyway. I don't care how much it costs. If there's a danger a child is being hurt, we need to figure out how to pay for it. I would never say we can't put these cases for investigation because it might cost too much. I agree we do need to look at it, but I don't understand where they would get $6 million anyway. That makes no sense to me whatsoever, because a case is, how would they know how much it's going to cost each department around the state to come up with a number? To me, that's a very interesting methodology. Yes.
One question for that, how much are these lawsuits cost in the state?
Well,
Okay.
again, you can't put a value on the
Yeah,
life of a child, so I
no,
don't even.
not at all.
I don't want to talk about
I
that.
do have a question though. Does anybody know if DCYF investigators are required to take an oath like a police officer is?
Oh, I don't know. I don't know that that's relevant. What's interesting is, are they mandated reporters the way as a school teacher, as the way Representative LaSalle mentioned? Because police officers' oath is more about the Constitution and
Well,
DCYF. No, obviously they
There's
probably.
a police officer is
sworn.
supposed to uphold the laws of the state of New
They're
Hampshire, and
sworn.
DCYF worker, I think they're ill-equipped to do it.
In some cases, perhaps, definitely. Representative Lynn.
Yeah, no, the only point I was gonna make is I'm really confused about the $6 million figure also, because I think, as Representative Mannion pointed out, as I understand this bill, it does not change the standard for reporting.
It's time.
So it's right, it's just a sort of time thing. So, and I think it does say in which there is reason to believe. So it seems to me that that's not a very high standard, but at least if the police or if DCYF, if it's completely clear that some claim is frivolous, that there just wasn't any, then I think that would not meet that standard, even though it's a pretty low standard.
Agreed. Also, well, if it's my understanding to get the fiscal note, the agency involved is called. So if they call DCYF and DCYF said, well, you know, because they didn't want, if I recall, they were against this bill. Is anyone here from DCYF? We'll have you up next. So I would think the $6 million number came from them. Otherwise, they would have had to poll every police department in the state and said, how much is this going to cost you? And I don't think that they did that. Anything further for Representative Love before we hear from DCYF? Thank you, Representative. Please come up and address the committee. Perhaps you can shed some light on the $6 million.
Good morning. My name is Marie Noonan. I'm the DCYF Director.
And my name is Susan Larrabee. I am General Counsel for DCYF. Good morning.
So I'd be happy to address some of the questions that were just previously discussed in testimony. First, I want to explain that DCYF Child Protective Service workers that conduct investigations do receive thorough training as they enter into the DCYF workforce. We have a core academy. Specifically, the types of CPSWs that conduct investigations are called assessment CPSWs, and they do go through interview and investigative training as part of that initial training. In addition, there are requirements for 30 hours annually thereafter. In addition, we offer refresher trainings. We often offer multidisciplinary opportunities for local law enforcement, child protective service workers, county attorneys to come together to talk about the joint protocols that we'll probably discuss in a moment that drives the practice for the joint investigations that take place between DCYF and law enforcement. At the present time, DCYF is partnering with the Attorney General's office to have a refresher investigative training that will take place for supervisors this fall and CPSWs at the first of the year. So we're always looking at opportunities and ways to ensure that our field line staff have the investigative and other kinds of trainings that they need in order to do their job. So I first wanted to address the training piece. Do you want to speak to that?
And I will add that I think it seems to be conflated in terms of, yes, our investigators, our assessment workers, they're not investigating criminal acts. They're investigating the civil action. If there's enough evidence to bring forward a civil action, a petition for abuse and neglect, it is the criminal investigators, the criminal detectives, like the detective who testified so well earlier, they are part of the MDT, the multidisciplinary team that was created by this legislature under 169C 34A, the multidisciplinary team, in which there is a joint investigation. It is not the same investigation. It is a parallel investigation in which we are child-centered, focusing on the best interest of the child and keeping that child safe. And it is the police who are investigating. Did a crime occur? How can we hold an offender criminally responsible? So we work together on these. And I think sometimes it gets conflated when we call them investigators. They are assessment workers who are trained to assess whether or not there has been the civil action of civil abuse or neglect.
Thank you. Okay, so let's address the issue that the bill actually is dealing with, the time frame of the calls and the reports.
Yes, and that's why, again, as we all know, doing fiscal note impacts, it's very difficult. We have to take it as it is, black and white. And absolutely, there is no additional requirements of reporting. The catch-all is that bottom last, a victim of any crime. So that's very comprehensive. So much so that there are, last year, there were 7,888 calls to intake that rose to the level of there being a possible child who was a victim of a crime.
That's I don't want to interrupt you, but that's already in statute. That's existing language. That's not part of the new bill.
Right, exactly. What the difference is the time frame. So right now, our central intake is open 24/7. During the daytime and non-holiday or weekends, it is manned by internally, our central intake. During after hours, as well as weekends and holidays, it is manned through a contract. They make a decision at that point whether to what's called screen it in for investigation and assessment or to screen it out. However, some screen outs do result in a call to law enforcement. That was 1,137 calls to law enforcement by central intake because it was a screen out. It was not a referral into DCYF for an assessment. However, there were 7,888 calls that were also assessed for abuse and neglect, as well as referred to law enforcement. That then goes to the district office, the local district office where the event occurred. That district office then calls the local police department and starts the joint investigation, saying, hey, we have this intake. We're going to fax you over the written report, and that begins the process. There's different time frames. As I pointed out the last session, we have level 1, 2, and 3s, and that also gives us guidelines as to when to begin that investigation with the police. So this change would be that all 7,888 would be immediately referred to law enforcement by central intake or our contracted provider. That would mean that they'd be calling a local police department. If there was no one on call at that point to speak to a live officer, they would then be making that verbal report to state police. And then based on our methodology, we assume that that meant that that state police would then be investigating that case. Then they would fax over the written assessment, the written intake, and the joint investigation would begin at that point within 24 hours, Saturdays, Sundays, and holidays included, for all screens in, not just the level 1s, in which that's already happening for level 1s.
Is the $6 million a cost to DCYF or what you're assuming it's going to cost law enforcement?
That's the cost for DCYF, for the changes in the time frame of what our after-hours contractor would be doing, what our daytime screeners would be doing, and then the on-call addition to pay our on-call staff to be able to make additional notifications to law enforcement.
It's going to cost $6 million for them to make phone calls, to make 7,000 phone calls?
And written notifications. So those thousands of referrals today do not, the excluding the weekends and holidays changing to including is going to generate thousands of additional written notifications that need to be made in a sooner time frame than is today. So today
Agreed,
it
but
happens, it doesn't happen in the time frame.
anyway, if they're making it today versus 3 weeks from today, why is it costing $6 million more if they're doing it anyway? Okay, so divided by 3, $2 million per year. Still, I don't know if it's already being done. Their testimony is that we do these, but we don't do it that quickly. Why is it costing more money if it's the same work?
What I'm hearing is that speeding it up is not so simple as just, it's not a simple process. Putting in the administrative structure to speed it up as required by the statute is what would cost more money. Is that what I'm understanding?
That's true. In addition, the addition of the state police. So one might assume you're not reaching a duty officer, and it sounds very simplistic to anyone. You make a call, you wait, you make another call, you try to call dispatch, you're calling someone. Is there a duty? Oh, we'll wait 10 minutes. You'll call us back. Oh, now I'm on the phone. Now I've got to call you back. Right. And then so then we determine there is no duty officer. Then we've got to figure out, okay, so we need to call the state police barracks in the right town over that. Then we call them, we wait. So it's not as simple as it sounds to make these kinds of notifications, make sure we're actually talking to a live person to be able to pass the information over.
Thank you.
And again, it's the only change of practice in terms of, yes, we're still referring those cases, but we're referring 7,000 of them immediately. So that also has a lot of unintended results of do certain level 3s then flood it so much that these level 1s aren't being addressed immediately? So I think this fiscal note would be, I hate to say zero, if that B did not exist, calling state police within 24 hours. Everything else is in line with what we are already doing.
Police within 24 hours is if you don't find a local law enforcement. Is that correct? Is it,
Yeah.
has
Yes.
it been has it been your experience that there's a town in New Hampshire, you can't get in touch with the police department within 24 hours?
Yeah.
If they could answer.
It's possible, or some have sheriffs that cover after hours, but we can usually reach someone, but it doesn't mean that joint investigation necessarily starts at that
Right.
moment. So I think the intention of this bill, the spirit of the bill is to speed up the process.
Uh-huh.
And the other piece is that exclusion of or now including Saturdays, Sundays, and holidays, is the other big change here. So yes, in letter B.
Okay, I get it. Thank you. Anyone else? Who? Oh, Representative Chair.
I want to shift to another focus. Do you have a copy of the legislation in front of you? I'm looking at 1C that reads, law enforcement shall not rely on the department to gather information for its investigations. And there's an unless clause, unless such reliance is required or necessitated. You talked about a team that includes law enforcement, and I think the officer from Newport talked about cooperation. I'm concerned that paragraph would needlessly fracture the cooperation that is currently going on. Am I over reading that too aggressively, or?
I'm reading that to say that the law enforcement just doesn't take DCYF's say there's no crime here and not investigate. That's what, maybe I'm reading it wrong.
Yeah. And it does point to the joint protocols, 169C 38A, which describes that we are to have joint investigations, it's a parallel investigation. And then 169C 34A, which is not referenced in this bill, which I think would even add more clarity when it describes what what is made up of the multidisciplinary child protection team, who's part of that investigative team, how are they to share information, and how are they to do their own investigation in line with the model protocols that we have established as best practices to make sure that we are, child-centered at all times, where police are also police focused and police-centered in terms of offender focus, such as the CAC, right? We all gather at the CAC for there to be one interview of that child. There are times when possibly law enforcement could not attend that. We would provide that to law enforcement,
Is
so
this
there's not
like
duplicative interviews of the
Like a
child.
sane interview type of thing you're talking about, like where they would have a nurse investigator?
A forensic interviewer who
Right.
specializes in child interviews.
Yes.
Correct.
That's part of the joint investigation process, which is,
Yes.
and they normally testify in court
Correct.
cases, so that wouldn't be a reliance only on them. But
So
Representative Mannion.
It doesn't get in the way of what you already do.
No, this wording does not. No.
Yeah, so the difference here is I'm the investigating officer. I'm not gonna just sit back and get the file from DCOF and say, no, and make a determination. I'm gonna conduct my own investigation as they would with any other crime. That's all that's saying is law enforcement shouldn't rely solely on their report as their complete investigative tool.
That's the way I read it as well. Representative Muse.
Thanks. I'm not sure you get this question from folks in the legislature a lot, but more often than not, what we do is we try to re-engineer the process ourselves, and you folks have to live with the consequences. If you were to take a look, if take a look at the objectives, some of the problems that you've heard about, and maybe look at some ways that you could have high impact on things like increasing reporting times, having fewer cases fall through the cracks. What would it look like? What would be the levers that you would move? What are the things that you would change?
I think having qualified, competent, sufficient numbers of staff, our workforce is our greatest asset at DCYF. If we don't have, numbers of investigators and numbers of ongoing family service caring caseworkers, right, we're unable to fulfill our mission. So if I'm thinking specific to this bill, as Attorney Larrabee mentioned, it's really just that one area that's most significantly impacting the process that we have today. I think otherwise, relying on our multidisciplinary teams and the joint protocols that we have with the Attorney General's office, which are under review for revisions, which are always opportunities to fine tune our joint practices, which is wonderful. Is I think how we best strengthen opportunities to ensure child safety as it relates to this bill. But if you're asking me specifically, what's most helpful, I think it's ensuring that agencies have funding and support to be able to staff their agencies appropriately in order to carry out their missions.
I guess in terms of being a little more finely nuanced with the legislature, if you look at 169C34, it talks about our duties of the Department of Health and Human Services, and we have talked about the level ones. The level ones are the emergencies. We need to get this joint investigation commenced immediately, and it is defined here as if it appears that the immediate safety or well-being of a child is endangered, the family may flee, or the child disappear, or the facts otherwise so warrant, the department shall commence an investigation immediately after receipt of this report. And I think that's the very specific language that already exists for us to do our job in a timely way. And I think maybe if we can put that into that subsection of B, that if no duty officer is available pursuant to 169C34, when we are commencing our investigation, that's when we reach out to state police and say, by law, let's work together. Let's start this investigation immediately because there is a child whose well-being is immediately in danger.
Under the section you just mentioned, 169C4, I believe you said.
169C34, the
C34.
duties of the Department of Health and Human Services.
Okay, under that section, what's the realistic timeline from when the call comes in to when that would be triggered?
When it comes into DCYF?
When DCYF gets the first call to when you would actually trigger the section you just mentioned?
I think each case comes in with its own unique set of facts and circumstances. But if we've determined that a child is in danger, what we do is we commence an investigation. So as you're seeing, some of the work that we do excludes weekends and holidays. So our commencing of an investigation includes weekends and holidays, meaning that for any level 1, 2, or 3 reports, so those are all reports that are screened in for investigation, we will take a step to begin that investigation to ensure until we're going to make our face-to-face contact within the 24, 48, or 72 hours that we're ensured that that child is safe. If when we commence or make those initial steps, we determine that the child is in danger in any way, then we would reach out to law enforcement to begin to work other arrangements or work with the Corps as needed to be able to intervene to ensure that child's safety immediately.
I don't think he answered my question.
So what would the time frame be?
Yeah.
It could be the same day. It could be the same because we're commencing an investigation the same day it's received. It could be a day later because our latest face-to-face contact would be 72 hours after a call comes in based on screening. So it could be within the first 72 hours.
And that's a level
situation.
1.
A level 1 would be 24 hours.
24 hours.
So it would be that same day we would commence.
Regardless, weekends, holidays.
Exactly, yes.
And you would contact law enforcement at that time?
Absolutely. We always have an on-call supervisor. So say if it's a hospital's calling with a child who is there injured, that would result in central intake calling the on-call supervisor who would commence that investigation immediately, report it to law enforcement, work with them jointly, and best practices arrive at the hospital at the same time to begin their joint investigation. And that MDT would be commence.
So that's within 24 hours. And that's what the proposed language calls for, is it not?
But for all
Right.
assessments. whether
Okay,
it's
so
one,
whether
two,
it's
or
1,
three.
2, or 3. Thank you. Representative Muse, did you say you had a follow-up? Okay. Anyone else? Seeing no one else, thank you for your information. What's that?
Thank you.
Wait a minute, hold on.
Excuse me, can you just repeat your name on the left? I didn't get it for the record.
Sure, Susan Larrabee.
Thank you so much.
Thank you.
And thank you for coming back today. All right, with that, we're going to move on to the next bill, which is relative to mandatory minimum sentences. We already dealt with this with a House bill last year, so it was my intent to propose that, wait a minute, which one is this? SB 15? This is one that we're having a public hearing tomorrow. There's another one that we already did a House bill on. It might be the next one. SB 41. SB 15, we're not going to discuss today because it's a public hearing. We're not going to preempt it. SB 41, changing reckless driving minimum penalties. Did we not pass the House bill version of this?
We did.
Yeah, we did. Okay, so I'll be moving to ITL this afternoon. The next one is relative to cooperation with federal immigration. We already dealt with that, I believe, as well in the House bill last year. So unless anyone has anything to add, we'll be moving to ITL that as well. And the next one relative to the crime of aggravated driving while intoxicated. Again, did we not deal with this in a House bill, I believe? Yeah, that we did. And the governor signed it. It's law now. So that will be also recommended to ITL this afternoon unless anyone has an objection. So with that, what's that? That was 71 cooperative. Yeah. Yeah, we already passed a law dealing with that last year too, as well. And the governor signed it. Yes, Representative McGuire, please.
Thank you, Mr. Chair. I have an amendment that I developed with Representative Rhodes, who can't be here today.
Mm-hmm.
You have a copy of it.
Which one is
When we passed the drone law earlier this year, I noticed a flaw in it that we were incorporating the CFRs without a revision or an effective date or any other identifier, which would allow the FAA to change their rules at any time without notifying us or allowing us to comment. So it's also unconstitutional because as I'm sure you've noticed when you're dealing with rules.
Yep.
So this is a bill, this is something I propose to put in as a bill, but if you amend Senate Bill 49 to it instead, that's one less bill you have to deal with.
Agreed.
So all it does is that it changes the reference to the 14 CFR Part 107, which is about drones, to include the latest change date, which is July 24th, 2025.
So this is, just to be clear, this is a housekeeping actually change to an existing law. You consulted already with the state police, am I correct?
Yes, in
Lieutenant
fact,
Storm?
Lieutenant Storm suggested that I use this bill as the vehicle because it would be not only simpler but faster.
I'm going to let him take credit for that. That's okay.
Well, I was trying to talk to you.
Yeah, no, I know, and I apologize. You actually called me, and I didn't get back to you. I had pneumonia, and I wasn't calling anybody back for a period of time.
So anyway, I
Yeah.
did get in touch with Representative Rhodes. She agreed with me that it needed to be fixed. And
Yep.
so that's why it's got her name on the amendment.
And that's great. No, I meant the part is the idea of just doing it with this instead of a whole new statute. I actually called Lieutenant Storm and told him that, but that's okay.
You could have called me and I'd take
Is
care
anyone
of it.
here from?
But
no one's here from the
it'll
state
be
police?
simpler to do it
Yeah,
here
I agree.
rather than have a new bill.
Anyone else want to address this? It's really, like I said, it's simple housekeeping. All right, thank you for coming in, and I'm sorry I made you wait so long. I should have actually called you up since you were here. With that, we'll, did you, go ahead. Yeah, I believe everyone has a copy. It went around. It says Amendment SB 49 FN. So with that, I guess we'll just take a break, and we'll reconvene at 1 o'clock. And we will, take up executive session on the bills we've discussed. And, if I could have, the Republican members please meet me before you take off for lunch in the next room. Anyone here from the public that was here for something, I don't want to make sure anyone came. And all right, thank you. We are on break. What? Oh, yes. Let's see.
I think it's 2013. And I did submit written testimony. I know it's an executive session, but just other pointers.
Yeah, got it. I'm just looking for the amendment.
So just a couple points. It seems like the committee may
Yeah,
not.
could you introduce yourself,
Oh,
please?
I'm sorry. Gail Drobat, Amherst, New Hampshire. At private citizen, yep, advocating for court reform and protection for children. RSA 633-4 is already a crime to interfere with child custody. It's a misdemeanor and it's a felony currently. Nobody wants to charge anyone with that. This amendment simply gives, I guess, kind of a warning, because law enforcement can say, if you don't hand over the child, it's a $500 fine. It protects children, it protects parents, it protects domestic violence. And if they are keeping a child for domestic violence reasons or child abuse or neglect, current law also states that they have 72 hours to petition the court to get that addressed as well. None of this is happening. Children are going months, years without seeing one parent because of bad behavior of the other parent. This protects children most importantly, and enforcement needs to be done. And if you call law enforcement, they don't keep track of these calls. They don't even show up to take a report on most of these calls. I've spoken to several police departments and there's no record. So somebody mentioned there's no record. This is a one-off. There's no record because they're not even showing up to the call. So if we can protect children at all costs, I think we need to really start doing that. And on my handout that I gave you, it also addresses these inferior laws violating constitutional rights. We really need to address that because it gets into deprivation of rights under color of law and all that. So children get one childhood. It needs to be a nice one, simply with both parents and all family members. So
Thank you.
I appreciate you letting me.
No, absolutely. And I appreciate you as a citizen coming in to share your thoughts with us. You're welcome. Is there any other citizens here that wanted to testify or talk about one of the bills before we break? Seeing none, we are now on break until 1 o'clock. And Republicans, please meet me in the next room.
I put in legislation.
It's running a little bit late again. So we're gonna begin as soon as he gets here. Should be here shortly. There's a lot of traffic, I think, out there.
Bear with us a minute. We're trying to get our paperwork ready. We have a replacement clerk. Sue Newman, are you replacing our clerk? Alexander Murray? Yeah. Okay. Representative Murphy, I understand you have an amendment you'd like to introduce, and I will wait. We'll hear the amendment. I
Great,
can't
thank you.
guarantee we'll pass
They're gonna
it.
bring it right in. Thank
Okay.
you so much.
Okay, I'm going to open the executive session on House Bill 102. And I recognize myself to make a motion of inexpedient to legislate.
Second.
Seconded by Representative Prue. Wait a minute. Got to make sure that's recorded. Hello, Representative DeSimone. Welcome back. Okay, so I made a motion of ITL, and it was seconded for the first one by Representative Prue. I'll speak to my motion. I think that we've looked at this issue and the complexities involved with regard to jurisdictional issues make it just impossible to actually, even if we wanted to implement it. We heard from the sheriffs who this would actually put this burden on, and they were not interested. And furthermore, based on the bill we passed last year with regard to cooperating with federal law enforcement, our sheriffs are working very closely with immigration already. So I feel like at least the intent of this is already being carried out. Would anyone else like to speak? Seeing no one, the clerk will call the roll. The motion on the floor is inexpedient to legislate.
Representative Mannon,
Yes.
Representative Prue,
Yes.
Representative LaSalle's,
Yes.
Representative DeVoit,
Yes.
Representative Lynn,
Yes.
clerk votes yes. Representative Saborn Dishwinner,
Yes.
Representative DeSimone,
Yes.
Representative Harriet Garthright, Representative Muse,
Yes.
Representative Newman, Ray Newman,
Yes.
Representative Murphy,
Yes.
Representative Sue Newman,
Yes.
Representative Swanson,
Yes.
Representative Shear,
Yes.
Chairman Roy.
Chair votes yes. What's the vote? How many people? Yeah, the vote is unanimous, inexpedient to legislate. And do we have any objection to consent? Seeing none, I'll go on the consent calendar. With that, I close the executive session on HB 102. HB 194. Who's bringing that amendment?
That was me, sir.
Okay, I recognize Representative Chabon Deschanel, did I say it right, to make a new motion.
Cool. So this amendment is for the relative to the crime of interference with custody. It's the three strikes amendment. First and second offenses for custodial interference are subject to a $500 civil penalty payable to the municipality. Third offense becomes a Class B felony under RSA 633-4 if committed within the state. If the child is taken out of the state in violation of custody order, offense is treated as a Class B felony on the first offense.
Representative, so you make a motion to introduce an amendment? It needs to be seconded.
Oh, My apologies.
That's okay.
I'm introducing amendment 2025-3019H.
Okay, I second. And now, would you like to speak to your motion?
Okay. Should I just repeat all that or? Okay, cool. Continuing on, this amendment is not about punishment, it's about deterrence, accountability, and protection of family bonds.
Thank you. I believe we've discussed this pretty much quite a bit, but we are, of course, in executive session. Anyone is free to repeat themselves if they wish. I support the amendment. I think that Representative Scher's point is well taken with regard to introducing people into the criminal justice system. However, this amendment gives them 2 opportunities to civilly correct themselves. And there may be opportunities before it even gets to that. So I feel like there's numerous opportunities to avoid a criminal penalty in this. And we did hear, I believe, that this is an issue with law enforcement not being able to or wanting to get involved in it. So this clearly indicates at what level and how they will get involved. Representative Scher.
I primarily rest on what I had to say earlier, but I think what needs to be done is law enforcement needs to be educated. And I think this problem would be greatly reduced if law enforcement was educated that they should be getting involved. Regardless, without this legislation, they still should be getting involved. And they're not. There are existing statutes that allow them to do so. So for that reason, I'll be opposing the amendment.
Representative DeSimone.
Thank you, Mr. Chairman. I've had the unfortunate opportunity to be involved in court cases for about 6 months. I've been listening to these cases. I have not been a litigant, nor have I testified. However, the police that I have spoken to, the judges that I have spoken to, need laws. They need the assistance to be able to go out and do their job because children and family are getting hurt, because they don't have something like this to help them. So I would ask people to reconsider and make sure that the family's safety is paramount.
Thank you. And I would add also that, like any criminal law, there is prosecutorial discretion in that this doesn't mandate that police charge or mandate that county attorneys prosecute. It gives them a tool in their toolbox. Any further discussion? Seeing none, the motion on the floor is to adopt the amendment. The clerk will call the roll.
Vice Chair Manning?
Yes.
Representative Pruitt?
Yes.
Representative Lascelles?
Yes.
Representative Voigt?
Yes.
Representative Lynn?
Yes.
Clerk votes yes. Representative Saborn Deshornaire?
Yes.
Representative DeSimone?
Yes.
Representative Harriet Garthwaite?
No.
Representative Muse?
No.
Representative Ray Newman?
No.
Representative Murphy?
No.
Representative Sue Newman?
No.
Representative Scher?
No.
Did you miss one?
Chairman Roy?
And Chair votes yes.
I missed another one. What? Swanson. No.
Sorry, Representative Swanson?
No.
The motion to adopt the amendment carries by a vote of 9-7. I recognize Representative Saborn Deshornaire to make another motion.
I motion we ought to pass as amended.
I second that. Any further discussion? Seeing none, the clerk will call the roll. The motion on the floor is ought to pass as amended.
Representative Manning,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative DeVoyd,
Yes.
Representative Lynn,
Yes.
clerk votes yes. Representative Sabor and Dishwinner,
Yes.
Representative DeSimone,
Yes.
Representative Harriet Garthwaite,
No.
Representative Muse,
No.
Representative Ray Newman,
No.
Representative Murphy,
No.
Representative Sue Newman,
No.
Representative Shear,
No.
Representative Swanson.
No.
And the chair votes yes.
Sorry.
And the motion carries by 9-7, and the on to pass is amended. And that will obviously not be going on consent. I close the executive session. Yeah. Who's going to do the minority report? Representative Shear. We need that. Who? No, you got to tell me now. We're up against the deadline. Who? Oh, okay. All right. As long as I know before I leave today. I need the report in the next day because we are up against the statutory deadline or constitutional deadline to have all of our bills disposed of. I will be opening, okay, the executive session on, where are we up to, 2:06. I'm going to continue this executive session until tomorrow. We're going to, there's another amendment for that one that's going to come through, so we will take this up tomorrow. So I open the executive session on 2:06, and I recess the executive session to tomorrow on 2:06. With that, I open the executive session on HB, is this one yours, Representative Murphy? The one, no? Oh, yours. Okay, HB 330, and I recognize Representative Shear to make a motion. Right? Yeah. Oh, I'm sorry, it's 257. That's correct, 257.
I move to adopt the amendment 2025-1038H.
Do we have a second?
Second.
Second by Representative Murphy.
We, we had a substantial discussion about this. I think the officer from Newport was very helpful in his testimony. I think we're at a place where let's try this out. We've got a good balance here. We can find out, in 2 or 3 years whether it's working or not. But I think this substantially addresses the issue with reducing the mental state to recklessly, and I'll leave it at that.
Any further discussion? Seeing none, I will ask the clerk to call the roll. The motion is to adopt the amendment.
Representative Manning,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative DeVoyd,
Yes.
Representative Lynn,
Yes.
the clerk votes yes. Representative Sabor and Dishwinner,
Yes.
Representative DeSimone,
Yes.
Representative Harriet Garthwaite,
Yes.
Representative Muse,
Yes.
Representative Ray Newman,
Yes.
Representative Murphy,
Yes.
Representative Sue Newman,
Yes.
Representative Shear,
Yes.
Representative Swanson.
Yes.
Chair Roy.
Chair votes yes. The motion carries. The amendment is adopted. I recognize Mr. Representative Shear to make another motion.
Second.
Who said that?
Linda.
Representative Gathright seconded that. Any further discussion? I'll just add that I think that it's not everything that the sponsor hoped for, but I think that based on the testimony we heard, that it may accomplish what, or at least take a good step towards what the attorneys were hoping to get. And it gives them another opportunity or a tool that they didn't have previously by changing the definition of that. So I agree with ought to pass. The clerk will call the roll. Motion is ought to pass with amendment.
Representative Manning,
Yes.
Representative Prue,
Yes.
Representative LaSalle,
Yes.
Representative DeVoyd,
Yes.
Representative Lynn,
Yes.
clerk votes yes. Representative Saborn Dishwinner,
Yes.
Representative DeSimone,
Yes.
Representative Harriet Garthright,
Yes.
Representative Muse,
Yes.
Representative Ray Newman,
Yes.
Representative Murphy,
Yes.
Representative Sue Newman,
Yes.
Representative Shear,
Yes.
Representative Swanson,
Yes.
Representative Roy.
Chair votes yes. The motion carries unanimously. Any objection to consent? Seeing none.
Mr. Chairman,
Yes.
it's an FN. Can it go on?
Is there an
Consent.
is there a fiscal note though? Everything had an FN on it this year.
That's my only question. There is a fiscal note.
Oh, there is?
Yeah,
Okay, well,
but it is zero.
yeah, that's what I've seen this year.
So I'm just curious. I would hate to see.
Well, it doesn't matter. If I put it on consent, they'll just kick it back to the regular calendar, I believe. So we're gonna try.
That's why you're the chairman?
Yeah, we're gonna try and put it on consent. Representative Sherr, you'll be doing the report on that. Thank you. With that, I close the executive session and open the executive session for HB 330, and I recognize myself for a motion. I move inexpedient to legislate.
Second.
Seconded by Representative Prue. We discussed this, but I'll just reiterate that there are many intersecting laws, both federal and state, with regard to this. And I think that there are better vehicles to accomplish this if one were necessary. Further discussion? Seeing none, I ask the clerk to call the roll. The motion on the floor is inexpedient to legislate.
Representative Manning,
Yes.
Representative Prue,
Yes.
Representative LaSalle,
Yes.
Representative DeVoyd,
Yes.
Representative Lynn,
Yes.
clerk votes yes. Representative Saborn Dishwinner,
Yes.
Representative DeSimone,
Yes.
Representative Garthright, Harriet Garthright,
Yes.
Representative Muse,
Yes.
Representative Ray Newman,
Yes.
Representative Murphy,
Yes.
Representative Sue Newman,
Yes.
Representative Shear,
Yes.
Representative Swanson,
Yes.
Representative Roy.
Chair votes yes. The motion carries unanimously. It's inexpedient to legislate. Any objection to consent? Seeing none, I want consent. I close the executive session. I open the executive session on HB 609. Let me see, who was going to make a motion on that? 609. Did you write that down?
I'll make a motion. I'll have to pass.
Thank you. I second. Would you like to speak to your motion?
I think most of this is already in law.
I think it was actually Representative Charbonneau that was going to make that motion, but okay. No, that's all right. Go ahead. Continue, Representative Prue.
If you would like to make the motion, I'll let you.
We'd have to withdraw the motions. Go ahead. Just go.
Anyway, I believe most of this is in state law already, and this is firming up what's already there and making it apparently clear that only the state can have authority over these items and not towns or other entities. Again, private property, that's a whole nother story. They can ban whatever they want, but public buildings and public places, not the case.
Thank you. Well said. Further discussion? Representative Muse.
Yeah, I'll be opposing this because essentially what it does is it doesn't necessarily just transfer this power to the state. What it does is it transfers it to the general court, and it takes it away from anybody else in the state who would try to, or in any subdivision, who would try to regulate any of these weapons. So as I said, during our argument before, it calls into question whether or not the New Hampshire National Guard could continue to restrict weapons and other things from being carried onto Pease Air Force Base during the air show that we do every fall. Bottom line is there are a bunch of different things that I'm not sure we've adequately looked into, and that we really should drill into more before we just pass a very broad, sweeping bill of this nature. This is not a cleanup bill. This is basically something that would override the practices of a lot of different communities. It would further impact and restrict local control and people and communities to be able to make these decisions for themselves. And it would take away the ability of the National Guard to actually provide security during our air show. And I think it calls into question whether or not we would continue to be able to have an air show at Pease without these types of restrictions. So hard no.
Thank you. Any further discussion? I would, Representative Lynn.
Yeah, no, I would say just to take the other side of the argument just made, it seems to me that what Representative Muse pointed out is exactly the reason that we ought to pass this. It's for the legislature to decide whether the National Guard should have the authority to ban firearms, or the Department of Transportation, as was referred to. That is the job of the legislature. So I think it's entirely appropriate. Presumably, if we were to decide that we couldn't have the air show because of it being federal property, it would not allow it unless there was a ban on firearms. Then presumably we would make a decision as to whether we think the air show is worth it to the is important enough that we ought to say, okay, fine, we'll allow the banning of firearms during the air show. But it seems to me it is clearly the responsibility of the legislature rather than the National Guard through some regulation or the Department of Transportation through some regulation or whatever. So I think that the points that Representative Muse make really reinforce the idea of the importance of this.
Thank you. I would say that I suspect the whole Pease thing is a straw man anyway. It's a federal Pease is a federal Air Force base. They have the right to restrict firearms if they want to, and this legislature can't do anything about it. So this law, I do not think would impact it in any way, shape, or form. So it's really irrelevant to address this to Pease or the National Guard when they're under federal authority. It's really not the issue. The issue is, do municipalities or other state agencies have the ability to regulate firearms versus the legislature, as you so eloquently said, and it is the legislature's job. Representative DeSimone.
Thank you, Mr. Chairman. I have a question of the chair.
Yeah.
Isn't it true that in this state we have 237 communities and thousands of businesses? Therefore, if this bill does not pass, it leads to the possibility of thousands of regulations as opposed to one regulation, one law that would govern the entire state?
You are correct, except for the part where you said businesses. Businesses are free always to make their own regulations for their own property, and people are free to frequent them or not based on that. But to your point with regard to the municipalities and agencies, you are correct. Every municipality could have a different rule or regulation, and every agency could set a rule or regulation. You may be able to go into the Department of Motor Vehicles, but then again, you may not be able to go into another one. No one can keep track of all that. That's the point.
Thank you, Mr. Chairman.
Thank you. Representative Scheer.
That may be a theoretical case, but we've existed without this law for a number of years, and that actually hasn't happened. So I think that is, to use the chair's term, a straw man.
It is the law currently, but it seems we need to redefine it or narrow it or explain it through this, because we have had state, to your point, state supremacy with regard to firearms for a number of years. And the reason this is being brought forward is because some places have chose to ignore that and put their own regulations in. So both are true at the same time. With that, I ask the clerk to call the roll. The motion on the floor is to ought to pass.
Representative Mannon,
Yes.
Representative Crew,
Yes.
Representative LaSalle's,
Yes.
Representative DeVoid,
Yes.
Representative Lynn.
Yes.
The clerk votes yes. Representative Saborn Deschwener.
Yes.
I was doing so well. Representative DeSimone,
Yes.
Representative Harriet Garthright,
No.
Representative Muse,
No.
Representative Ray Newman,
No.
Representative Murphy,
No.
Representative S. Newman,
No.
Representative Shear,
No.
Representative Swanson.
No.
Chair votes yes. 9-7. Motion carries 9-7 ought to pass. Representative Prue, you kind of got wrangled into that motion. I'll write the report.
Thank you.
You're welcome. I'm nice like that. Again, with the minority report, please let me know before you leave today. We'll be doing it. That I close the executive session on House Bill 609, and I open the executive session on 767. And Representative Murphy, do you have a amendment you'd like to introduce?
Yes, thank you, Mr. Chair.
We need a motion in a second.
Oh.
So we have a motion. Someone second that, please.
Second.
Second by Representative Gath, right? There you go. Would you like to speak to your motion?
Sure, yes. Amendment 2025-3032H addresses a couple of the issues that were raised and clarified during this morning's work session. Essentially, I think we're all on the same page with recognizing the need to do what we can to protect children. And the amendment essentially just changes 1A, the lines 2 through 5, by referencing the RSA that was mentioned by the DCYF attorney earlier this morning, the duties of the Department of Health and Human Services, and it keeps the rest of the bill as introduced the same. The only other thing it does is it changes part 1B and removes the section of the written report. It removes the section on if no duty officer is available to receive the verbal report, the department shall verbally report to the state police. I understood from DCYF that isn't really necessary, and because I questioned, well, don't we have law enforcement in the local areas or coverage, sheriff or whatever? So it actually sort of complicates things by bringing in another agency where it just makes sense to have the agency that's law enforcement agency that will be moving forward to investigate the case, keep that. So it's unnecessary. The second part of that was it just reverts to current language regarding the written part of the report being required within 48 hours and excluding Saturdays, Sundays, and holidays. So the verbal report has to be immediate within that first 24 hours. It doesn't change that. That also, by removing this and allowing for the original language regarding the submission of the written report, it also addresses the issues with DCYF having to increase the contract time and everything else. And I think it's been my experience that if a law enforcement agency needed it more quickly, that they would certainly get that. I can't imagine that would be a problem. So I'd be happy to support that bill with these amendments, as I believe it still addresses the sponsor's intent, and it doesn't complicate things for either law enforcement or the division.
Thank you. Anyone else want to add something to it? Representative Muse.
I just wanted to point out too that this also addresses a lot of what was accounted for in the fiscal note. So in a non-budget year, not having to find $6 million is not a bad thing.
Thank you. Representative Murphy, if everyone doesn't mind, we're gonna take a minute so we can actually look at this and digest it. So I'm gonna recess this. We'll take it back up at the end when we're finished everything else. And we're gonna move on to another bill. We're gonna take a recess so we can discuss it in caucus because we haven't really had a chance to talk about this. But I'm not in immediate objection to it. So we're gonna go ahead and take a break on that one and pick it back up in a few minutes. And I'm going to open the executive session on HB 767. And what?
That's the one you just did.
That's what we just did.
Oh, I'm not gonna do that then. I'm gonna leave that one on the table for a second and open SB 41, changing the reckless driving. And I'm going to recognize myself for a motion of any expedient to legislate.
Second.
Seconded by Representative Harry Gathright. This was taken up last year with a House bill that passed and was signed into law by the governor, and therefore is not necessary. So anyone, any further discussion? Seeing none, ask clerk to call the roll. The motion is an expedient to legislate on SB 41. Actually, yeah, go ahead. Just keep going.
Representative Mannon,
Yes.
Representative Crew,
Yes.
Representative Lascelles,
Yes.
Representative DeVoyd,
Yes.
Representative Lynn,
Yes.
the clerk votes yes. Representative Saborn Deshwiner,
Yes.
Representative DeSimone,
Yes.
Representative Harriet Garthright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy,
Yes.
Representative S. Newman,
Yes.
Representative Shear,
Yes.
Representative Swanson.
Yes.
Representative Roy,
The chair votes yes. 16-0, inexpedient to legislate. Any objection to consent? Seeing none, it'll go on consent. And I hereby close the executive session on SB 41. Just for to make things proper, SB 15 should not have been on here because it's scheduled for a public hearing, but I'm going to I just wanted to note that for the record, that not that I'm skipping it, it's that it's been scheduled for a public hearing tomorrow. With that, I open the executive session on SB 49, and that's establishing the crime of the unlawful use of unmanned aircraft. I'm going to recognize myself to make a motion to introduce amendment number
2025.
3024. Can I get a second?
Second.
So that was seconded by Representative Lynn. I'll just speak to this real quick. We already talked about it. It's a housekeeping measure that includes the dates that are necessary and should be in there constitutionally to make this work as it should. Any further discussion? Representative Scher.
Just to make sure, I assume this is a replace all amendment.
No, well, yes, because, yes, it is.
Get rid
Because
of-
we passed the actual, the House version of the bill, so this is a replace all amendment that, however, it's obviously very, very germane. A replace all amendment, yes. Any further discussion? Seeing none, the motion is to adopt the amendment.
Representative Mannon,
Yes.
Representative Crew,
Yes.
Representative Lascelles,
Yes.
Representative DeVoyd,
Yes.
Representative Lynn.
Yes.
Clerk votes yes. Representative Saborn Deshwiner,
Yes.
Representative DeSimone,
Yes.
Representative Harriet Garthright,
Yes.
Representative Muse,
Yes.
Representative R. Newman,
Yes.
Representative Murphy,
Yes.
Representative S. Newman,
Yes.
Representative Shear,
Yes.
Representative Swanson,
Yes.
Representative Roy.
Chair votes yes. The motion carries unanimously to adopt the amendment. I recognize myself for further motion to OTPA.
Second.
Thank you. I will say we really, everything I just said, this is a housekeeping bill and we've adopted the amendment and that's all it really does is change the law that we already passed by fixing the dates necessary. Any further discussion? See none and ask clerk to call the roll. The motion is to ought to pass as amended.
Representative Mannon,
Yes.
Representative Crew,
Yes.
Representative Lascelles,
Yes.
Representative DeVoyd,
Yes.
Representative Lynn.
Yes.
The clerk votes yes. Representative Saborn Deshwiner,
Yes.
Representative DeSimone,
Yes.
Representative Harriet Garthright,
Yes.
Representative Muse,
Yes.
Representative Newman, right?
Yes.
Representative Murphy,
Yes.
Representative S. Newman,
Yes.
Representative Shear,
Yes.
Representative Swanson,
Yes.
Representative Roy.
Chair votes yes. The motion carries unanimously. I will write the report. Any objection to consent? Seeing none, I'll go on consent. I close the executive session. I open the executive session on SB 71 relative to cooperation with federal immigration authorities, and I recognize myself to make a motion of inexpedient to legislate.
Second.
Seconded by Representative Prue. Again, this was an issue that has been dealt with by previous legislation and is unnecessary. Any further discussion? Seeing none, I ask clerk to call the roll. The motion is inexpedient to legislate.
Representative Manning,
Yes.
Representative Prue,
Yes.
Representative LaSalle's,
Yes.
Representative DeVoyd,
Yes.
Representative Lynn,
Yes.
clerk votes yes. Representative Saborn Dishwaner,
Yes.
Representative Simone,
Yes.
Representative Harriet Garthright,
Yes.
Representative Muse,
Yes.
Representative R. Newman,
Yes.
Representative Murphy,
Yes.
Representative S. Newman,
Yes.
Representative Shear,
Yes.
Representative Swanson,
Yes.
Chairman Roy.
Chair votes yes. The motion carries inexpedient to legislate. Any objection to consent? Seeing none, it'll go on the consent calendar, and I hereby close the executive session. I hereby open the executive session on SB 149 relative to the crime of aggravated driving while intoxicated. This was passed via a House bill last year, therefore making the Senate bill unnecessary. And I recognize I already said that motion expedient to legislate. Can I have a second?
Second.
Seconded by Representative Prue. Any further discussion? Seeing none, I'll ask her to call the roll when she gets her paperwork squared away.
Representative Manning,
Yes. Yes.
Representative Prue,
Yes.
Representative LaSalle's,
Yes.
Representative DeVoyd,
Yes.
Representative Lynn,
Yes.
clerk votes yes. Representative Saborn Dishwaner,
Yes.
Representative Dismoni,
Yes.
Representative Harriet Garthright,
Yes.
Representative Muse,
Yes.
Representative R. Newman,
Yes.
Representative Murphy,
Yes.
Representative S. Newman,
Yes.
Representative Shear,
Yes.
Representative Swanson,
Yes.
Chairman Roy.
Chair votes yes. Motion carries inexpedient to legislate unanimously. Any objection to consent? Seeing none, it'll go on consent. I close the executive session. We are going to take a break until 2 o'clock. Republicans, please meet me in the next room so we can discuss the amendment by Representative Murphy. Okay, I'm reopening the executive session on House Bill 767. We've looked at the amendment. Well, let me just pick up where we are in the process. Representative Murphy has introduced an amendment, and we'll be voting on whether or not to adopt the amendment. And this is discussion further on that. We've discussed it, and we don't necessarily not like the amendment. However, this reference to 169C34, that's a huge section of law, and we tried to go through it and to see if it, and we can't determine whether or not, why is it included, first of all? What does it do? Why does that have to be in there, that in accordance with part? Because a concern is, immediately means immediately. So can you address that for me, Representative Murphy?
Sure, thank you, Mr. Chairman. That was the recommendation of DCYF, which explains their duties. And I think it's just because it delineates what their expectations are in their reporting requirements. So I didn't see a reason to object to that suggestion, so included it.
Like I said, our concern is that it's a large section of law that touches on a lot of different things. And another question, the way this is written, it says RSA introductory paragraph, RSA 1A is inserted by section 1 of the bill by replacing it with the following.
Yep.
And it's only A. So the way it's written, it looks like this is now the entire section 1. So we lose B and C. Do you see what I mean?
And the introductory paragraph.
Because if you're replacing that whole thing, you know what I
yeah,
mean? It
yeah.
looks like this is now the only section, so it gets rid of the rest of them.
Oh, but it says the introductory paragraph 1B with
Right.
B.
Wait a minute, let me just read
Yeah,
it.
it's just on line 10. I think it clarifies that it's not replacing the whole paragraph.
Right, but Mr. Chair, but in the problem, I think the problem is when you, in the first part where you
Yep.
say, paragraph 169C38 1A, the introductory paragraph, is that just 1A, or does it just that one paragraph, or does it include subsections 1A1, 1A2, 1A3, 1A4, 1A5, 1A6? It's not really clear. You could read it either way. And so it's kind of ambiguous as to, in other words, are you replacing 1A subsections 1 through 6 with just 1A?
No.
But it's not, I mean, you could read it either way. That's the problem. And the other thing I see is, I understand your purpose in having that introductory clause in accordance with the duties of the department. But I think part of our problem is that section 169C34 is a pretty long section, number one. And number two, to the extent that it defines the duties of the department in some way that could be read to be inconsistent with what we're trying to do here. In other words, I think what we are trying to say is, look, you have to do this. You have to provide notice immediately. And if there's something in 169C34 that, is somehow could be regarded as a little bit ambiguous as to what they have to do or when they have to do it or that kind of thing, I think that could be a substantive issue that would be inconsistent with what we are trying to accomplish, I think.
Yes, let me just, if I could, please. It defers to that section. In other words, so this amendment says, here's what we want to do as long as we're deferring to this section of the law. And if that section of the law is inconsistent with we want this immediately, in other words, if 169C34 says, we're going to make that call within so many hours or so many days or whatever, it defeats the purpose of it. So we've got some concerns with it. However, what I'm willing to do is we've discussed it, and we're gonna vote no on the amendment, and we're going to vote to pass However, I will go on the record to say that if you want to work with me on a floor amendment, we can co-sponsor the floor amendment and I will support it and so will the rest of the committee, as long as we don't get rid of the whole purpose of that law. Would you be amenable to that?
Could we just make a comment first before we make a change there? Could you stated that this does not say immediately, but it actually does. It says immediately verbally report to an on duty.
Yeah, but what is that? What is it? Again, though, that first sentence
Yep.
that says it's going to be done in the accordance with RSA 160 will do this. So in other words, everything that follows after that has to only be done in accordance with that section of law. Representative Scher.
Yeah, I read it differently on the theory that you read what appear to be conflicting statutory provisions if they can be read not to conflict.
They're supposed to be read that way.
Yeah,
right?
and the way I read this, it says that what comes after the in accordance phrase says that's how you interpret 169C34. It requires that their duties under 169C34 be interpreted that way. That's how I read it, and that is consistent. You know, that makes it reading the I'm using the power of speech. You understand what I'm saying?
Yeah. What do you say to that?
Yeah, you know, I mean, I guess what I can certainly agree with you that that is one permissible construction of this. But the very fact that, you know, maybe that is not the only permissible construction. And so to the extent that there's an ambiguity, I think one of our big problems is we just haven't had the chance to really go through line by line what 169C34 says.
How about let me suggest this, just to see if we can not have to go all the way to a floor amendment. If we were to change the in accordance with the duties, in addition to the duties, change it to that, and have that amendment ready for tomorrow, and we can do it.
Well, why does 169C34 have to be in this amendment at all? That's an issue I have, because, I mean, why? It's already law.
Because if it's not there, then the department says, well, does this completely get rid of what we're supposed to do under 169C34, or is this an addition to 169? So that's why I think the in addition language makes it abundantly clear from both sides. Without it, there's confusion for DCYF. With the in accordance with, I understand what some are saying, though I disagree. But if you just make the language in addition to, rather than in accordance with, I think everybody knows what it means.
What do you think?
Yeah, no, I mean, I guess I agree with that. I agree with what you're saying, but it doesn't address the other issue. I think there's some ambiguity as does this amendment replace subsection A 1 through 6 with just subsection A? No. Or does 1 through 6 continue? And I think that, again, is an ambiguity. You could argue it either way, I think.
No, I think we can fix that pretty easily overnight.
Again, in an effort to not have to go to a floor amendment and all that, I would agree to recess the hearing until tomorrow if you get an amendment that says in addition to, and it clarifies that that's not replacing the rest of it.
And just to make this simple, Representative Lynn, how would you clarify that second issue? What language would you put in?
I would just repeat, I would put in 1 through 6 in the amendment. You see what I'm saying?
Yeah,
just put that language in.
Okay.
Copy and paste the whole thing, and then just change what you want to change.
I'll replace all amendment with, okay, I get you.
No, you don't have to do the whole bill. I think he just means put in the whole section that.
Right, put in one section, subsections 1 through 6.
Yeah,
right.
and then just change paragraph A.
Yes, that's very reasonable.
Okay, all right, then that's
Great.
what we'll do. Everyone seems to be pretty much in agreement with that.
Thank you.
And I think that what you wanted to do is perfectly fine. You agree that there should be immediate reporting. It's just a matter of how we do it without injuring the department.
Right, thank you.
And I agree. Okay, we're going to recess on HB 767 until tomorrow, which we'll take up after the public hearing when we do whatever we have left. And with that, Wait a minute, was there something else that I was taking, I was gonna reopen?
206?
Yeah, was that it? Hold on.
Well, that's for tomorrow, 206.
No, but there was one thing I think, hold on a second.
I think we're good. You know what you have to do.
Yeah, so just
Just in here, in here.
changes to,
Two.
in addition to
Right.
the duties, and then list 1 through 6.
1 through 6
Yeah.
with the,
With the-
with, yeah.
I don't understand why. Like,
Yeah.
that's pretty good. I know.
Does anyone recall, 206? Did I open that, and officially?
Yes, you did, and you continued it till
Tomorrow, okay. All right, I just don't know why. I feel like I said I was gonna take something up this afternoon and then, but
I think you were taking up the legislation about the Peace Development Authority in the air show.
yeah, but we took care of that, didn't we? Yeah. All right, so we're good. I will see whoever's gonna be here tomorrow. I thank you all of our subs today, for coming and taking part in our program. I also like we could have charged admission where we had a legal debate between the former Chief Justice and one of the prominent
Is he
defense
gonna
attorneys.
keep subbing in here? or-
Yeah, that's the whole reason I request him actually, because, yeah, something. As you know, tomorrow morning, we have a public hearing. It's a contentious, as always, type of bill, but I want to make sure everyone knows we're going to keep everything civil, and we're just going to talk about the facts, and if it goes one way or the other, that's fine. But let's just keep in mind, yeah, no fun, no hijinks and nothing like that. Yeah, exactly. All right, see you all tomorrow. Thank you.